Hi, good morning, everyone. And for those in Europe, good afternoon. We're delighted to have you here to address this important topic in M&A deals. I am John Beeson. I am Jones Day's global leader in life sciences M&A. And as a result of that, my practice focuses on M&A life sciences transactions, and you will hear later about the prevalence of earnouts in life sciences transactions. So this is something that myself and my co-presenter, Mike Murray, deal with on a daily basis. So we're excited to share some of our insights with you. Mike, you want to introduce yourself briefly?
Yes. Hi, everyone. Good morning and good afternoon to those in Europe. This is Mike Murray. I lead the M&A team here in Jones Day's Chicago office. And like John said, we're very happy to have everyone. Looks like we have a fantastic turnout for the program today, and excited to talk about earnouts and life sciences M&A.
So why don't we dive right in? These will start at a pretty high level, and then these will get harder, I promise you. We realized as we're putting this presentation together, we could probably talk for 4 or 5 hours on earnouts. We are not going to do that this morning, but if you would like a follow-up presentation or have questions after the program, feel free to reach out to us. If you have questions during the program, you can type those into the Q&A chat box, and we'll try and address those as we're able. So first of all, just to level set in terms of what we're talking about when we see what an earnout is. And one of the things that an earnout is a mechanism for the buyer to pay consideration on a post-closing basis if, and the key here is only if, a specified milestone is achieved. You will see sometimes deferred purchase price, which is really carryback financing, or working capital adjustments. Those are post-closing, but that's not what we're trying to address today. So really, the quintessential use of an earnout is to bridge a valuation gap between what the buyer, who is new to the business, is willing to pay for a business that has operational risk, and the seller, who understands those risks very well, is willing to accept from the buyer on a risk-adjusted basis. So there'll be a gap. So the buyer may say, you've given me some rosy projections, you've given me some rosy development paths for a particular pharmaceutical or medical device or diagnostic or whatever it is, and assuming those milestones are achieved, I would be willing to pay full value for this business. But sitting here today, I can't understand whether they're going to be achieved or not. And the seller says, well, I want to capture full value for the transaction. And so there's this valuation gap that we need to bridge. So the seller can get comfort that now, if the value is actually realized, they'll share in the upside. But there's going to be some protection that the seller says, I need to make sure that the buyer is going to try hard. I'm going to make sure that I'm going to benefit from the upside of the business if the buyer actually hits those milestones, and they want to make sure that they are actually going to receive the payment. So we'll talk about some of the risks in just a minute. The other thing a seller may say is, this is a really great deal for me because my key employees will stay with the business oftentimes. They will have some real effect on whether the milestone can be achieved. I can benefit from synergies that the buyer will bring to the table. So sometimes we will see, we'll talk a little bit later about some of the triggers of what milestones will provide a trigger for an earnout payment. And the seller says, look, the buyer has better resources than I do to hit those milestones, and therefore the likelihood of getting there actually goes up. And so the likelihood of me sharing in this value goes up. From a seller's perspective, you can also defer taxes, assuming that we structure these, and we're not going to get into tax in detail, but assuming we structure these for installment sale treatment, I can defer the taxes that I pay on a portion of the purchase price. I only pay it when I receive it. And then from both parties' perspective, you can use the earnout payments as security for the seller's post-closing indemnification obligations. And in the seller's case, the seller says, that sounds good because I will try and cap my liability at all or a portion of the earnouts if and when paid. So I'm looking at this as upside and gravy in the transaction, and therefore my liability on an indemnification basis can be similarly limited. So let's talk about some of the risks. There's lots of benefits that we just talked about. What are the risks to including an earnout in the structure? And the first thing that comes to mind, obviously, is disputes, right? We're kicking the can down the road in terms of not agreeing on value today. And the parties will have to then agree whether the earnout was achieved and whether the buyer used appropriate efforts to achieve the earnout. One court put it this way: business value is frequently debatable, and the causes of underperformance equally so. So an earnout often converts today's disagreement over price into tomorrow's litigation over the outcome. And so, in other words, we call earnouts litigation magnets. And we're going to discuss that a little bit further as we go into this presentation. In addition to disputes, while we're getting rid of the negotiation over the value proposition, we're introducing a number of new terms to the transaction, and so they can become time consuming to negotiate. We need to get the legal terms right. There's going to be accounting treatment and internal valuation on the buyer's side that need to be addressed. And then there's many tax aspects, which we're not going to deal with here, but can be addressed. This is a series of presentations that Jones Day is presenting, and so can be addressed in the tax aspects when we get to that in a future presentation. The point being, now you need lots of experts weighing in, both internally and externally, to make sure that these things are addressed appropriately. The other aspect of this is, having done this hundreds of times, I can tell you that you cannot address every scenario. There's going to be a level of trust between the buyer and seller. And so as a seller, you should be looking at your buyer as a partner and looking to see, is this something that they do on a regular basis, so that you can see how they have treated other sellers in the past. Primarily from the seller's perspective, you now are giving up control of the business to the buyer. And the only way to get that back is to identify the control that you will have, or the commitments that the buyer will make in the purchase agreement. The seller really wants the buyer to actively pursue those milestones and to maximize the earnout. That would be the seller's nirvana. It's not likely to happen that the seller is getting a commitment for the buyer to maximize the earnout, but that would be what the seller wants. Seller also wants to make sure that it's not going to give up value in the business when the milestones are achieved, or when there's a dispute over whether a milestone has been achieved. And on the other side of the coin, the buyer wants to make sure that it's not overpaying for the business. In other words, that if a milestone is not achieved, that it's not going to be on the hook to pay the earnout. And that's where the fundamental locking of horns comes when negotiating the earnout. Let's talk about why these come up in life sciences deals, and Mike's going to talk in a minute about the prevalence of earnouts in life sciences deals. We're seeing, and this has been a continuing trend over a number of years, in life sciences deals, they're at an earlier and earlier stage. And so you've got a number of development points that have to happen with a product oftentimes. On the device side, there may be re-engineering that has to go on with the device itself. And so there's going to be significant valuation inflections that need to occur over the life of that product for each party to understand the true value of the business. So we're using earnouts more and more and punting to bridge that gap. So Mike, why don't you continue on?
Thanks, John. So John has given you the background on what earnouts are and are not, and has also talked about how and why earnouts are used in life sciences deals. What I'm going to do now is I'm going to throw a few statistics at you and also tee up a couple of topics that John and I are going to talk more about later in the presentation. First, about every 2 years, a company named SRS Acquium comes out with a study that surveys deal terms and other metrics from a very large sample size of life sciences deals. The most recent survey just came out in September, so a few months ago, and this chart that you're seeing on your screens now and a few of the other charts in the presentation slides that John and I prepared includes information that SRS reported in the study. I love this slide you're looking at now because it really reinforces what John's already mentioned, which is earnouts appear in a consistent majority, a huge number of M&A deals in the life sciences world, upwards of 85% if you look at the chart according to the SRS study in the biotech and pharma space, and not far below that in terms of the medical device and diagnostics and research space. What I love most about this chart is it really does reinforce how important it is that life sciences, people involved in life sciences, M&A and transactional work understand the nuances to earnouts, how they work, what the milestones are, and what the risks are from both the buyer and seller's perspective. Because if you look at the black line at the bottom of this chart, that's a separate study that SRS does on non-life sciences deals, and you'll see just how different the deal dynamics are in non-life sciences deals where earnout provisions are included in only about 15% of the deals that were included in the study. So John mentioned this before, but there's been a surge that we've seen in a market trend, especially in the last couple of years, that the potential earnout payments has increased rather dramatically. We've especially seen this, and this is consistent with what the SRS studies reported in the biotech and pharmaceutical space. If you look at the top right of the chart that's projected on your screen, you'll see just how dramatic of an increase there's been in terms of the number of milestone events, in particular in biotech and pharmaceutical deals. The number of different milestone and earnout triggers that are included in a deal averaged just over 4 about a decade ago, and now we're up to over 10. So that's one takeaway that I had from kind of looking through the most recent SRS study is just how many more milestones are being included in life sciences deals, which is consistent with what John and I and others in our life sciences practice are seeing in the market. The other key takeaway from this slide should be just how significant of dollars we're talking about that are at stake. And that goes to John's comment about bridging the valuation gap. One of the things that I didn't include is more details kind of by year on the ratio of the upfront payment that buyers make in life sciences deals to the potential earnout payments. What I can tell you is that number, especially again in the biotech and pharma space, has ranged, depending on the year of the study, anywhere from about 3 times, meaning that the earnout potential was 3 times as much as the initial upfront payment, to about 5 times the upfront payment. So the most recent data set they have, the last 2 years in the biotech and pharma space, it's about just under a 3-to-1 ratio, where there's about an average of $550 million potential earnout payments included in every deal, and the upfront payment average for what they studied was about $250 million. So now let's just spend a couple minutes on the types of measurements that are typically used to measure whether a milestone or whether a earnout's been triggered and the payment amount that is due from the buyer for an earnout. Earnout measurements typically fall in one of two buckets, either product development focused milestones or quantitative financial performance and other quantitative metrics used to measure success. The chart that you're looking at shows the frequency of use of these two types of earnouts. So the left-hand side of the chart, the kind of the blue shaded area, generally signifies what I would describe as product development milestones. And those include things, excuse me, things like the start and the success of various studies that are going to happen in a program's development, everything from that to receipt of regulatory approvals along the way. The right hand of the chart, which is kind of the green shaded area, reflects what I would describe as financial metrics and other quantitative measurements that are used to ascribe additional value that the buyer would have to pay to seller if targets are met or if the quantitative metrics are met. Two observations on the types of milestones. First, the success of studies and regulatory, basically the product development milestones, tend to be the hardest ones to negotiate and to draft and to think through the what ifs. There's just so many variables, and it's so fact specific in terms of how those are negotiated and drafted into contracts. Everything from kind of what the patient population has to be in a particular study to whether there's geographic limitations or what geography a particular regulatory approval has to relate to are things that typically are negotiated and set out in the contract very specifically to define what the earnout milestone is. In terms of financial metrics and other quantitative performance metrics, there's sometimes a tension between what sellers want and what buyers want here. Buyers, typically would prefer financial metrics that are lower than the top line number. So not just sales, but they would want to take into account expenses and how much it cost and how much they had to contribute in order to take a program from development stage to where a product is ready to be marketed and sold in particular jurisdictions. Sellers, on the other hand, typically prefer to measure the revenue line or sales line or number of units sold. That's a much more common way that you see life sciences earnouts shake out is to measure and calculate earnouts based on top line numbers. One of the reasons why you tend to end up there is number one, it takes a lot of the discussion, or not a lot, but some of the discussion out in terms of covenants that John's going to talk about later in the presentation. And number two, if you start getting to a lower number like an EBITDA number or a net sales or profitability number as the trigger for an earnout payment, you end up negotiating what all of the ins and outs are going to be, and you often end up with pages and pages of rules in the contract, and it just becomes kind of the deal fatigue type situation where parties will get exhausted and decide to do something else. The last slide in this portion of the presentation is really just meant to reflect that it's not just defining milestones that you need to think about when you're negotiating an M&A deal in the life sciences space. There's a lot of other provisions that go into a typical earnout provision. The post-closing covenants are the most important topic on the list that you're seeing, and John's going to cover those in more detail later in the presentation. But the gist of it is that you have to negotiate specifically what the buyer is contractually obligated to do or not to do during the earnout period in order to try to achieve or maximize the milestone payments that would be due to the seller. Two things I'll make, and then I'll pass the baton back to you, John. One is in setting the earnout period, one trend one thing that you very frequently see in life sciences deals are graduated or time-based earnout payments. This typically benefits both the buyer and the seller. This, from a seller's perspective, you don't typically want a hard deadline or kind of an all or none type earnout because it creates bad incentives sometimes on the buyer side to drag feet, where you're just missing an earnout deadline and suddenly instead of getting the full earnout payment, the seller gets nothing. From a buyer's perspective, what time-based or graduated payouts often reflect is the reality that the value of a particular study or a particular regulatory approval tends to decrease the longer it takes to get a product to market, right? So if you can get your product to market in a couple of years after the acquisition, you're going to ascribe much more value to the target company than if it takes 5 years.
Okay, so why don't we dive in on negotiating earnouts? We've kind of set the groundwork in terms of what it is we're going to negotiate, what the interests of the buyer and the seller are. Um, so here we kind of talk about the perspectives again of the buyer and the seller. The buyer wants full control of post-closing activities and would love to say, look, I'm just going to run this business. You're coming to me as a professional company who does this all the time, who has these types of programs. We know what we're doing, and we're going to do what's right for the business. The seller rarely takes that at face value and accepts that the buyer is going to actively pursue the development of the product. The seller also wants the buyer to maximize their earnout payment, and that may be at the cost of long-term benefits. And so you could see that potentially investing in a product for a longer period, having a bigger study on a pharmaceutical may mean that you've got more robust data, easily get reimbursement, but that's going to take longer. The seller's perspective may be, I get paid upon product approval, and so I want the smallest, fastest study that we can put together that would get us to product approval. And so you need to get that dynamic set between the parties. Buyers need to understand, therefore, that in negotiating an earnout or putting an earnout in their transaction, you are no longer going to get a clean break on the business when you buy it. So we need to keep that in mind. As a result of this, the parties get to various buckets, and this is also from SRS, and identifies the types of covenants that buyers undertake. And you can see easily the most prevalent is a commercially reasonable effort standard that the buyer would undertake. And we'll talk a little bit later about how this is often defined with lots of words. This is not just, I will use commercially reasonable efforts. There is a definition of what that means and what goes into commercially reasonable efforts. Buyers are trying to be very specific about how they're going to approach CRE. But you'll see that the next largest bucket currently is express buyer discretion. And I will show you the next slide, and we'll flip back and forth a little bit. This is from the same study 6 years ago. And express buyer discretion was even higher then, as was commercially reasonable efforts. And so what we're seeing here is that buyers and sellers are moving away from express buyer discretion and away from commercially reasonable efforts. And they're moving more to express no bad faith actions. So the idea here would be that the buyer says, I will operate the business in a manner that is best for the business, but I will refrain from taking actions that are expressly in bad faith or that would be designed or intended to harm payment of the earnout. And that is a growing area. We'll see if that trend continues, but it's a growing area in negotiations between buyers and sellers. The other thing of note is the specific requirements. So this is where you would say the buyer will do X, Y, or Z. And you can see 6 years ago, that was a very small subset over there on the far left-hand side. That has grown significantly, both for development milestones and commercial milestones. And so there are certain things where the buyers and the sellers are saying it's definable in terms of what needs to be done, whether that's operating generally in accordance with a development plan that has been agreed upon by the buyer and the seller, or whether that's adding a particular budget requirement, or maybe it is to have a certain study size. Those are more easily determinable for milestones that are nearer in time. For those that go out several years, that's going to be a little more difficult to define because the landscape at that point in time is going to be unknown. I won't belabor this slide. I think what we're trying to show here is that commercially reasonable efforts and what that means is going to differ based on the jurisdiction in which you're operating and the applicable law under your contract. And the other point to make here is that these are squishy definitions. There is no bright line that defines what is a commercially reasonable effort. I kind of like the California one, something different than a promise to act in good faith and something less than fiduciary duty. How is that a standard that you can operate within? And so the parties need a lot of times to have a little more definition around that. As far as negotiating specific requirements, that's that category that's been significantly on the increase. Sometimes we see things like a specified revenue spend or a specified sales force size or the number of details that they will carry out in calling on physicians. There'll be a requirement for a certain amount of capital to be invested into the product or into the business. We don't, as from a buyer's perspective, we don't recommend those if you can avoid those. Oftentimes that can mean that you're going to find yourself with a program that you have to spend money on where that doesn't make sense anymore. And so a more general development plan without specific amounts to be spent on specific items and more of an overall budget or a general budget can be to the buyer and seller's advantage. The other thing is you don't want an obligation to manage for short-term profit, and you may want to even disclaim that. You can obviously see that maybe putting capital into the business now, which could hinder the payment of the earnouts in the near term, could lead to bigger growth down the road. And so you might want, from a buyer's perspective, to preserve that ability. Also won't go into this in detail. There are a number of other contingencies to ponder, and the buyer and seller often overlook these. You start to think about the program that's in place, understanding what the intention is, but obviously sands shift and things happen over time. And so what happens if there's a change of control in the buyer? We talked earlier about the fact that sellers would want to pick a buyer as a partner. You're going to have a certain level of trust in that buyer. So if that buyer undergoes a change of control, the people that are there may no longer be the decision makers that you were negotiating with. Depending on the size of the buyer, that may or may not matter. If you're dealing with a Fortune 50 company, the likelihood is that business will be as usual. If you're dealing with a very small company who's making an acquisition of your program, that may matter to you from a seller's perspective. Also, what if the buyer sells the program? You need to deal with that. There's some other things here that are, maybe less likely. Restructuring of debt obligations, bankruptcy protection. Perhaps there were key employees important to the business. What happens if they leave or are terminated? And what kind of effect would that be expected to have on the earnout payments? So those are things that need to be addressed. And sellers will often say, well, I just then want the full amount of the earnout payment to become due and payable. And the buyer will push back and say, we don't know that we've gotten value for the business, and that may mean without any real change in the prospects for achieving the earnouts, I'm forced to make a full earnout payment, and that's not acceptable. And so that's going to be something that's subject to significant negotiation. I'm also not going to talk a lot about this, but it's something to be aware of. One of the benefits from a buyer's perspective is that there are key individuals to the business that you're acquiring. Maybe it's a key scientist or research person, and they're going to stay on, and that's part of the plan. The earnout could be an incentive for them because if they're an equity holder, they have a share of the earnout. So they now are incentivized to work harder. There may be aspects of the earnout, though, where you can structure these to further incentivize them, but you have to be careful about the tax treatment of the earnout in those scenarios and whether that can turn an earnout into income, which a seller would not want. They want capital gains treatment on the earnout. So, Michael, turn it back over to you.
Great. Thanks, John. As you're passing the baton back to me, I think take a look at the Q&A box because you had a couple of questions that came in as you were giving part of the presentation. I'm going to go back and I apologize for missing it from one of the program attendees. We got a question that relates to something earlier that I had said. So just to answer the questions, because I'm guessing that if one person had it, a lot of people had it. So in the previous part of my presentation, I had mentioned that there was an increase in milestones, the number of milestones per deal in earnouts in the most recent kind of 2-year study versus what we were seeing 10 years ago. If you remember, and John, I haven't gotten control of I don't think control of the slides yet. Oh yeah, I have it. I'm going to go back to that slide just really quickly so people can see what I'm talking about. So in the past decade, if you look at the upper right-hand box here, the average number of milestone triggers in a deal went from just over 4 to just over 10. And the question was there any data in the study about whether those increased milestones were more on the regulatory product development side or on the financial performance quantitative side? The answer is no, there was not specific data on that, but I can tell you, and John can tell you from our experience, I think what's driving that and where the additional milestones are coming from are the product development related milestones. One trend, and I think John mentioned this earlier in the program, that we've seen, and I think everyone in the life sciences sector has seen, is that buyers are looking at targets earlier and earlier in a program's life cycle. So there's more acquisitions being made, phase 1 or preclinical, very much pie in the sky still kind of targets. And so what that's led to is many more product development geared earnouts being included to help bridge the valuation gap between what a seller thinks its kind of early stage company is worth and what a buyer is willing to pay up front and over time, depending on how the program develops over time after the acquisition. So hopefully that answers the question. John, do you I don't know if you want to answer, there were a couple of questions in there just to answer the questions that were tied to your part of the last part of the presentation.
Yeah, why don't you go ahead and get back to where we'll pick up. But the question to my portion was, what does the express no bad faith action mean for companies looking to prioritize development of their product over the seller's product? And so it's a good question. One of the things as you define commercially reasonable efforts is, when a buyer looks at the potential of the acquired product and compares that to other programs from a safety, a commercial opportunity, from an IP protection or regulatory protection perspective, can they take all of those factors into account in determining whether they push this program forward or what has become a more attractive program? And commercially reasonable efforts often defines that in a way where a buyer can prioritize other programs that have become more attractive. I don't think moving to express no bad faith changes that. If you're taking actions, the express no bad faith is usually an action that is intended to thwart payment of the earnout. So a good example would be if there were an earnout payment upon $1 billion of cumulative sales of the product, and the buyer sees that in the quarter prior to the deadline for the achievement of that earnout, that's going to be achieved, and so slows sales down to just miss the earnout. That would be an express bad faith action. The reason they did it was to miss the earnout. They otherwise would have wanted those sales, and they're taking the action to thwart payment of the earnout. If you're prioritizing a more attractive program, the reason that you're doing that is because it's a more attractive program, and I don't think you would be called to task for that. So Mike, why don't you keep going?
Great, thanks. Okay, so turning back to the presentation slides, now we're to the part where it's kind of the elephant in the room, and John mentioned it at the first part of the presentation. Deals that include earnouts are absolute litigation magnets. In particular, in the life sciences industry, I talked about how significant in amount the potential earnout payments are in life sciences deals, and you add that to what I'm about to talk about in terms of the types of claims that sellers sometimes make when earnouts are not achieved or are not achieved in the time frame that is required under the contract, and that leads to disputes. According to a recent study, 1 out of every 3 life sciences deals, so I'll say that again, 1 out of every 3 life sciences deals that involve some type of an earnout mechanism involved a dispute. Of those deals, about 50% of them were renegotiated and never progressed to the point where there was a full trial and a decision rendered. But 1 in 3 life sciences deals with earnouts involve disputes post-closing. So the renegotiated solutions can range from anything to termination of all further earnout payments or the earnout payment or milestone that's at issue in exchange for some type of a payment, of a portion of what would otherwise have been payable to seller, to renegotiation of the contract in its entirety or a particular milestone to either adjust the amount or to adjust the triggers as to when it would be paid. And then we've also seen at times, and I would say this is much rarer, but at times, if the dispute is significant enough, we have seen settlements where a buyer would give back, return some of the product rights or all of the product rights to the sellers as part of a settlement to basically make the dispute go away. Then I'm going to talk about the 2 types of claims. They generally fall into 2 buckets that you often see in disputes regarding earnouts. One is ambiguity in the contract language, and the other is seller claims that the buyer either did or didn't do what it was required to do under the contract in order to try to achieve the milestones so that the earnouts would become payable. So ambiguity in drafting is one of the areas where we see disputes that arise post-closing in deals with earnouts. What ambiguity means is that a judge or an arbitrator looks at the contract that's been signed and determines that either the intent isn't clear from the language that was used in the contract, or the language that was used is susceptible to more than one reading or more than one meaning. Common issues where contracts are sometimes ambiguous are in defining what the triggers and milestones are for earnout payments, and also sometimes you see them in hazy calculation methods. The most important point here that I'll make in terms of ambiguity is tying it back to a conversation that John just had, and the chart showing the increased prevalence of 2 things. One is a disclaimer by the buyer of any kind of level of efforts required to achieve the milestones, and 2 is if you remember, he noted that contracts are becoming you more often are seeing very specific and precise obligations as to what a buyer has to or does not have to do in order to try to achieve a milestone. Um, I, I, I think the reason why we're seeing this is because those types of provisions, the more you can address upfront when you're signing the contract, the less likelihood there is that 2 years after you sign it, there's going to be some claim that a provision in the contract is ambiguous or susceptible to more than one meaning. In terms of practical advice, one thing that I always focus on when I am negotiating a contract with an earnout is sometimes we lawyers and business development folks and other people who are in the trenches on deals um, become so ingrained in terms of what success looks like, or how the milestones are supposed to be defined, that there's a tendency to rely on kind of what's in your head versus what's on the piece of paper. And so one thing that I always focus on when I'm negotiating an M&A deal for a life sciences acquisition or a life sciences sale is making sure that that the contract includes even the most obvious things. So the most obvious, we've included a few of the questions here on this slide that we typically go through with clients as we're drafting and putting together provisions that define what the milestones are. Even the most obvious things that may be intuitive if you've been sitting in a room negotiating milestones and thinking about a transaction for weeks and months, are worth putting into the contract in most cases to make sure that the milestones are as precisely defined as you can get them so that you mitigate the risk of ambiguity in the contract 2-3 years from now, when it's being reviewed by a judge or an arbitrator that wasn't in the trenches with you and didn't have the benefit of all of the back and forth. So the second kind of bucket of disputes that often come up in terms of earnout provisions are related to efforts covenants and some of the topics that John just talked about in terms of what's negotiated in earnouts in terms of what a buyer has to do or doesn't have to do during the earnout period in order to try to achieve the milestones. In some cases, the contract is very clear on what the buyer has to do or doesn't have to do, but often you're left with provisions that are either include squishy language, like John mentioned, commercially reasonable efforts, reasonable best efforts, a commitment to operate the target company, consistent with past practices, or for the buyer to use efforts consistent with how the buyer pursues comparable programs or products. That's where you often get into these types of claims. So if an earnout includes language like this, a court applies either or both an objective or a subjective test, depending on the jurisdiction and the particular facts. An objective test asks what would any company typically do to progress the program or product that is subject to the milestone or the earnout. A subjective test, as you can probably guess, looks specifically at this particular buyer and this particular program to determine whether or not the buyer's actions were reasonable and from a subjective basis. It's often very difficult to predict how a court is going to come out on these types of disputes. But what it does do is it creates a very fact-intensive, usually prolonged and very expensive discovery process to try to determine intent and also to try to develop the facts so that the judge or the arbitrator can make a determination as to whether this squishy language has been complied with. And so that's one of the primary reasons, again, kind of flashing back to a previous slide, as to why you often see disputes end in renegotiation of earnouts rather than proceeding all the way to the litigation or arbitration stages that from both a buyer and a seller perspective, but in particular a buyer perspective, it can be very expensive, very time consuming to litigate these types of claims. If there isn't, one other point I'll make about types of claims that you see, if there isn't an on-point provision that a seller can point to in terms of making a claim against a buyer. Sellers often try to rely on the implied covenant of good faith and fair dealing to fill the gaps in the contract. So this is a very narrowly applied concept by courts, but it is one tool in a seller's toolbox if they don't receive an earnout payment, or if the buyer is claiming that the earnout payment is less or hasn't been achieved on the timeline that's been agreed. The the these types of arguments, a court's only going to apply the covenant of good faith and fair dealing if the court or arbitrator determines that the contract doesn't address a topic specifically. And so one technique, and again, this is going back to something John talked about, one technique that buyers use to try to mitigate the risk, and it's become increasingly prevalent in earnout provisions if buyers have leverage to get it, is insisting on a provision in the earnout that clearly states that the buyer has absolute and complete discretion over the program and over the operations of the target company post-closing. There's a recent Delaware decision actually that found that a provision like this essentially expresses an intent by the seller and buyer to opt out of the implied covenant of good faith and fair dealing, meaning that a court, if they're following Delaware precedent, if they see this provision in a contract, they should not allow a claim for good faith, for a breach of the implied covenant of good faith and fair dealing. The last thing is I just want to reemphasize, and I talked about this both in terms of claims that relate to ambiguity of provisions in contracts and in terms of claims that relate to what the buyer has or hasn't done during the earnout period. The reason why there is so much litigation is twofold. One is that earnout payments are very significant in amount typically, so they're very high stakes litigation. And two is that either threatening or bringing a claim by a seller often puts pressure on a buyer to settle, even if the buyer feels that the facts are in the buyer's favor, because of the fact that the types of claims that are prevalent in earnout litigation tend to be the ones that survive motions to dismiss or summary judgment at an early stage and proceed to prolong and protracted discovery and very extensive and time-consuming and expensive discovery. It also, because of the fact that earnouts tend to be very long-term, the number of documents that have to be produced in discovery and the time period that's covered often leaves, frankly, both sellers and buyers with some question as to whether a smoking gun is going to be found in some email or some witness testimony that would really sway either a judge or an arbitrator to find against that party because of things that were said or weren't said. There's two types of transactions that really get my antenna up when I'm working on them in terms of really having a hyper focus on kind of process and communications and negotiations with the other side. One is sales and acquisitions of public companies, publicly traded companies. And the other one are life sciences transactions with earnouts. And really the reason for that is those two types of transactions, there is such a risk of litigation combined with the fact that if there is litigation or arbitration or a dispute, the actions that a buyer or seller take, and including lawyers representing the buyers and sellers take, is really held under a microscope. And so anytime I'm working on one of those two types of deals, my antenna is even more up than it typically is as a lawyer, to make sure that there's a record that isn't going to somehow come back and bite you 2 or 3 years after the fact. So John, I will turn it back to you.
Okay, so we've kind of laid out negotiating it, where the disputes come up. So maybe let's kind of go back over a little bit in greater detail what it is that we've learned from all of these items and in negotiating various transactions. So these are the things that we'll talk about: drafting carefully being very specific about the obligations, and as Mike raised, disclaiming maybe the covenant in good faith and fair dealing or any other obligations, being specific about how the dollars are calculated. We'll get into a little bit of the math around uh, the the types of financial uh, benchmarks and some of the things that come up in discovery and disputes. So to dive in a little bit more on these, not belabor all of them, um, but one of the things, as we talked about, is as we see buyers and sellers punt, sometimes the in the where they want to go is to let's be silent, let's rely on the covenant of good faith and fair dealing, and this may be my opinion only, and not every practitioner's opinion. I don't think that's good for either a buyer or a seller because you really aren't defining what it is that needs to be done. And the buyer may have an expectation of what will satisfy that, and the seller may have a very different expectation, and both may be disappointed. So, from my perspective, I think it's better for both to be as specific as possible. Not using industry or colloquial terms is also important. This goes back to what Mike was saying in terms of trying to be specific about even things that may be obvious. And this also means getting the right people involved in helping to define the milestone payments. Get the scientists working with the lawyers, not just, and sometimes the business development person is a scientist, but not necessarily just the business development person saying, these are the general things that we've agreed on from a business perspective. Lawyers go put that in. You need a lot more interaction between members of the deal team to get precision on those milestone definitions. Another point on this is if the better milestone is going to be something that a seller understands a buyer will have a motivation to undertake regardless of the words on the page. And so if you're obviously getting a product approved is something that the buyer is going to want to do. They're paying good money upfront for this product. They have an incentive to go and commercialize that product. So that's a good, and it's why you see the prevalence there. Sometimes I will see parties come to agreement on milestones where the buyer will actually overpay upon the achievement of that milestone. So you look at it and say, well, there's not going to be sufficient profits upon the achievement of that milestone. Now the buyer's got an incentive not to achieve that milestone. That sets up a bad dynamic among the parties. There may be other things where the value associated with a milestone is not necessarily reflective of the value of the program upon achievement of the milestone. So you want to try and move away from those to the extent possible. So this is just to reiterate, this slide gets its own slide for a reason. Making a clear standard around the buyer's efforts is one of the most important things because it leads into the disputes, which we'll kind of get into a little bit later. On the dollars, having a floor or cap on the milestones can help narrow the discrepancy between a buyer's position and a seller's position in terms of what amount is paid if a milestone is or isn't achieved, or if there's a dispute over whether a milestone has been achieved. So putting into the contract, this is the maximum amount the buyer has to pay, or if there is a minimum amount under some circumstances, just specifying that from a seller's perspective. One of the things I see a lot is there'll be upon a product's approval or upon instigating a clinical trial for a product, there's this payment that will be made. Sometimes a product is defined in a way that there could be multiple products. And so the parties need to be clear about can that milestone be achieved more than once. The parties also need to be clear about if there's a specific product, and you think about it in the context of a transaction, sometimes you need to talk about products very broadly. When I get an IP representation provided to the buyer, I want that IP representation to cover all of the potential products that I'm acquiring or modifications thereof that are made by the seller prior to the closing of the transaction. Whereas it may be in the buyer's mind, I'm only paying a milestone upon a specific product without any modification upon its approval. And so sometimes you need more than one definition around that. Having liquidated damages can be a way to avoid disputes. It's often very difficult to determine what those liquidated damages would be. The seller would obviously say it's payment of all the remaining milestones. The buyer is often going to push back against that. And so one of the ways to solve that or help with any of these concepts, as Mike alluded to earlier, is having a more graduated formula rather than cliff payments. A graduated formula, if it makes sense from a business perspective and is reflective of value in the program, can allow achievement of a milestone that will placate a seller in some regards without having the buyer end up overpaying. Given time, I'm not going to go into this in any detail, but the point here is the financial provisions and milestones are often based on GAAP-based concepts. The buyer and the seller need to think about what GAAP applies. If you think about GAAP, everything's, well, specifically lawyers think, well, GAAP is GAAP, right? Isn't that going to be very specific? And the answer is often no. How you're going to think about collectability of receivables or bad debt allowances or reserves for warranty and product returns all need to be addressed because those can be things that are squishy within GAAP. GAAP could also change over the course of the earnout period. If you think about time periods in the 5-year range, GAAP may change. And so you want to lock down what GAAP can be used. A buyer will say, I don't want to have to carry 2 sets of books. If particularly large publicly traded companies have GAAP as they implement it for all of their products. And they'll say, we're the big boys, we're sophisticated, and as long as we're doing this for all of our programs, whatever we use in terms of GAAP for those is what we will use for this. And that will often be acceptable to a seller, but you really have to think about whether that makes sense in the context of the transaction. And one of the last things we'll touch on here is just the discovery. No matter what, you can have an integration clause. For the non-lawyers, that means we're just going to look at the contract and not look at other documents or behavior. We try and lock that down as much as possible, but when you get into litigation over a buyer's efforts, almost by definition, you need to go and look at what has the buyer been doing. It's a factual, intensive negotiation or investigation. And so defining what discovery is going to be available in the agreement can be important. From a seller's perspective, you may not want to have to rely on full-blown litigation. You may want discovery up front. And so information rights, where you can get some discovery, maybe on a limited basis, to determine whether litigation makes sense or whether arbitration makes sense. Another approach is to try and get ADR or alternative dispute resolution provisions in place so that you're not going to full-blown litigation, which can be expensive for both parties. The other thing is just to think about this from a managing the record while you're in negotiations, whether an earnout should have been achieved or was intended to be achieved in a particular way can also be a factual dispute, and that means going back and looking at communications between the parties when the transaction was being negotiated. And as a result of that, being very careful about your internal communications, understanding that just because an attorney is copied on an email does not make that communication necessarily subject to the attorney-client privilege. And so being careful about what you say in those emails. Jokes and sarcasm often come through in a very negative way in the middle of a dispute. And so that joke of, well, let's not be very specific about this earnout anyway, where it's never going to be hit, from the seller's perspective, could be very damaging when that dispute arises in the future. So with that, we thank you. I don't know if there's any questions that we need to address, but I know that we're a little beyond time. We appreciate your participation in this. And as I said at the beginning, if you have follow-up questions, feel free to reach out and contact us. We will also distribute the slides to attendees so that you will have those for future reference. And if you would like an additional presentation that goes more in depth on any of these points, we're happy to talk with you about that as well. So thank you for attending today.